This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we discuss why an appeal was dismissed by a New York appellate court, even with allegations that the plaintiff was involved in a fraud that needed recognition by the courts. The appeal was lost because the plaintiff, or the defendant, the party seeking the appeal, failed to provide the appellate court with an adequate record. In an action to recover damages for personal injuries, the defendant, Myrtle 6, LLC, appealed from an order of the Supreme Court, Kings County. The order, insofar as appealed from, denied those branches of the motion of the defendant, Myrtle 6, LLC, to stay the trial, to vacate the note of issue, and to compel discovery. The appellate court, in J. Bing versus Myrtle 6, LLC, dealt with the appeal and resolved it, finding that the record on appeal was inadequate. The plaintiff commenced this action against the defendant, Myrtle 6, LLC, and another defendant to recover damages for personal injuries. The defendant moved to stay the action, vacate the note of issue, and compel discovery. The Supreme Court, the trial court in New York, issued a stay of trial and granted leave for the defendant to amend its answer and allege various fraud defenses. The defendant alleged that there was a related criminal case pending against the plaintiff's previous attorney in connection to an insurance fraud scheme. Although the defendant's affirmation in support of its motion stated that the details of the fraud scheme were outlined in prior motions with exhibits, none of the prior motions or exhibits were included in the record on appeal. In an order after oral argument, the Supreme Court denied those branches of the defendant's motion which were to stay the trial, to vacate the note of issue, and to compel discovery. It is the obligation, the appellate court noted, of the person seeking to appeal a judgment, the appellant, to assemble a proper record on appeal. Generally speaking, an appellant's record on appeal must contain all of the relevant papers before the New York Supreme Court, being the trial court. In New York and in every other state, appeals that are not based upon complete and proper records must be, and usually are, dismissed. The appellate court observed that the record provided to it by the appellant was inadequate for a meaningful appellate review. The appellant failed to include all relevant documents that were before the trial court. The record failed to include the exhibits allegedly demonstrating that the plaintiff's former counsel was involved in a fraud scheme. Since these omissions have rendered meaningful appellate review of the court's order virtually impossible, the appeal must be and was dismissed. In my opinion, when a plaintiff's lawyer is under arrest for insurance fraud, the right of an injured party to establish a claim against the defendant becomes problematic. The appeal of the order allowing the plaintiff's case to go forward could have been effective, but failed because the record on appeal was inadequate. Of course, the appellant is not without a remedy. They can, as defendants, sue their lawyers for malpractice for getting this appeal dismissed because of an inadequate record. This video is adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. and you'll gain access to the more than 4,800 blog postings. You can also subscribe to these videos on YouTube or on rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in obtaining further detailed information, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.